to the Weekly Politics Show. I'm Councillor Premier with co-host Councillor Andrew Rood, and we're going to have an extensive discussion on the Upsana Begum trial, the prosecution brought by Tower Hamlets Council for housing fraud. On all three counts, the council she was found innocent by a jury. Andrew was there following this as part of the opposition group, and was there some of the days in the trial as well. So basically, we're going to start with a chronology and some basic facts, and then, given the time, go into analysis, and then next steps for Tower Hamlets Council and a wider ramification. So, Andrew, over to you. This kicked off, this investigation kicked off as soon as he was selected for MP in November. The story is broken by The Sun, where the journalists approached the council, and the council confirmed that they started an investigation on Upsana. You had the general election, she got elected as an MP, and then the council proceeded with this investigation. I think interviews were held January, February. I believe they're under oath, sort of ish.
Yeah, they were.
So whatever's given has to be true. And then basically it proceeded. You had the COVID-19 pandemic breakout. So the courts were closed for non-police prosecution. As soon as they started an application, I believe in May, the council applied for a summons to start the prosecution. The date of the hearing was in December. So standard practice is 28 days before the prosecution. The summons is issued to the defendant. That's when it broke out in the news as well, in various newspapers. And then we had an appearance in Westminster Magistrates in December, another appearance in Snaresbrook Crown Court, where they set the date for the trial, and we had the trial. Andrew, do you want to add anything else to this, the chronology I went through, which is all in the public domain, before we go into the facts of the case?
Yeah, so in terms of just over the last week, so the actual court started last Wednesday with the prosecution and a defense, and then the prosecution went first, followed by the defense. So they kind of only actually finished the prosecution case on the Monday, and then defense started with Upsana Begum herself giving evidence, and then John McDonnell MP as a character witness. Then Wednesday was then the prosecution and defense summing up, and then Thursday morning the judge, Mrs. Justice Whitpool, summarized the facts from her perspective, and then the jury was dismissed around sort of, I think, 12 o'clock on Thursday. They then asked a question late Thursday afternoon, which we'll come to later, because I think that's quite maybe the only clue we've got about what they were thinking about. And then they indicated this morning that they couldn't agree unanimous verdict. So the judge has said, she will accept a majority verdict. And then sort of in the middle of the afternoon, they came back and sort of said that they agreed a majority verdict, which was innocent on all three charges. Whether that was 10 or 11 out of the 12, I don't know. But it had to be at least 10 of the 12 jurors had to agree that she was innocent for that to happen.
So it's a dramatic turn of events, and the council laid three charges against Upsana. Let's just call her Upsana. So they laid three charges against her, one dating from 2011.
So it's 2013. So
2013.
Yeah.
Yeah. One, and then wasn't the initial one 2011, then 2013, and then 2015.
So the first charge was basically, so what, just a very brief summary of what happened. So in September 2011, she first applies to go on the council housing waiting list. So she just started work at Tower Hamlets Council in the mayor's office. She just left university where she studied politics. And then what happened was she then applied to go on the housing waiting list. And at that point in time, she was living in a house with 6 people in total. and I'll come later as to how many rooms, because that was one of the key issues. But everybody agrees that in 2011 that she was genuinely overcrowded. And then she the council asked her a few questions about her overcrowding status. And I think they then confirmed, I think it was January or February 2012, they then confirmed that she was overcrowded, and that she was what was called band 2 overcrowded. So she went onto the housing waiting list at that point. The first charge comes in January of 2013, because by that point, sadly, her father had passed away and her aunt had moved away. So it was no longer 6 people in the house. There were 4 people in the house. And they were arguing at that point that she didn't notify the council about the change of circumstances, because when she signed her application form in 2011, she had to confirm that she would tell the council if there was any change in her personal circumstances. But the key issue was obviously in 2013, in her original home, whether or not she was overcrowded or not. And it probably is worth me talking about the bedroom point at this point, because it's such a critical issue. And it was also clearly an issue that the jury were asking questions about. So the house that she lived in up until middle of 2013, and again briefly in late 2015, is a house with a kitchen, 2 bathrooms and a hallway. It then has 5 other rooms. It has been described in several places as being a 4-bedroom. When it was sold by the family in 2017, at that point in time, because we have pictures, because you can actually find this on Rightmove website, at that point in 2017, it had 3 bedrooms, a dining room and a living room. So the question is, how are those 2 rooms used, the dining room and living room, throughout this whole period? And Absama Begum said throughout the whole period from 2011 onwards, it was always 3 bedrooms, living room and a dining room. And that was one of the key issues. And it was a key issue in 2 ways. Number one, because the council disputed that, because they said that when her aunt applied to go on a housing waiting list, she described the home as 4 bedrooms. And then when her mother applied for council tax benefit, she described it also as a 4-bedroom house. But there was no direct evidence as to exactly how the rooms were being used during that period of time. And then another very important issue, and this is where the jury asked questions, is what is the council's own policy about how do you interpret those 5 rooms? Is that a 4-bedroom or is that a 3-bedroom? And this is where the prosecution had a lot of problems. Number one, because it wasn't written down anywhere. And then the second problem is that in the investigation, the council's investigator was talking to various housing officers. And I think he actually, and I've got lots of detailed notes I need to probably reread at some point, but I think what he said is that the prosecution would be ripped to shreds in court because there was a dispute within the housing department as to how you define that type of house. But the senior manager of the department, sort of what he said in court was in that particular case, the living room and the kitchen would not be interpreted as bedrooms, but the dining room could be. And the jurors were basically asking what he actually said about that particular issue. And then the judge and the barristers agreed, I think this morning, to read back to them what he actually said about that issue, even though the judge sort of said the policy wasn't relevant. But it was clear that the jurors were asking questions about exactly how you define that. And I think the other part of the problem is there are not many properties in Tower Hamlets where you have a living room and a dining room and a kitchen all separate from each other. And I think that's why there was so much uncertainty within a department as to how to define that. But you know, Absama Begum said it was always used as 3 bedrooms. And clearly the jurors either agreed with her wholeheartedly or didn't believe the prosecution case that it was a 4-bedroom, or else, which is another key issue, is
the bedrooms and the fact that we're basically there wasn't a fixed definition. If you just want to continue from there, please.
Yeah. So I lost you for about 20 seconds. So what I was saying is that there was no written down policy about how you decide a 5-room house whether it was, whether it, a living room, a dining room, and 3 bedrooms used by 3 or 4 people was overcrowded or not. And there were disagreements within the department as to how you interpret a 5-room house. And that was clearly something the jurors were interested in, because they were asking about the testimony on Friday morning by the most senior housing manager. And apparently, so I wasn't there on Friday morning. I was doing this in rotation with Councillor Peter Golds, but then we tell each other what happened. But all I can say is that the judge actually made a joke in the afternoon about the witness, i.e. the senior housing manager, falling apart in cross-examination. So clearly that was a damaging point in time for the council in terms of how do you define the use of these rooms.
So to summarize for our listeners and viewers, the main plank of the council's prosecution was that she made an application for living in overcrowding housing. They're claiming she wasn't, but they never had a fixed definition. So it was a complete blur. So you bring a prosecuting someone on something which is basically a strict liability. It's like either you have housing insurance, either you have motor insurance or you don't.
Yeah.
Either you're over the limit or you're not. Now, if you come and say the speed reading, we're not sure what the speed limit is, then basically a large plank of your prosecution against someone just falls apart, or we don't know the definition of what a motor insurance is. So that's kind of the lame example.
But in this case, what the judge was saying was, she had a duty in early 2013 to notify the council about a change in circumstances, and she didn't do it. So whether it was 3 or 4 bedrooms wasn't actually the key issue from the charge, is whether she notified them that she was no longer living with 6 people in total, but it was now 4 people in total. So that was their charge. But I think it is worth. Now we're about to go to a break, so maybe I'll wait till after the break.
So we're going to go into a short break, and then we're going to come back and let Andrew continue with his point about the judge's comment.